Hello, everyone, and welcome to One Civil Law. For today's story, we're going to discuss a case out of the First Circuit Court of Appeals from the federal system that says that the schools can trans the kids and parents don't have any right to know. So we get to keep secrets from parents. We get to teach the kids that it's okay to keep secrets from their parents and hide things because they're special things that are just between you and the child, and the parents aren't supposed to know. That doesn't sound problematic in any way. That doesn't sound like an issue, but let's read this case. We take our attention to the United States Court of Appeals for the First Circuit in the case of Stephen Foote versus Ludwell School Committee. Cool. This is coming out of Massachusetts because, that sounds like, yep, that definitely makes sense. All right, and we're going to read this thing. Per curum, courts nationwide have faced all manner of important litigation involving matters of gender identity and gender expression, including the use of folks' preferred pronouns. Today's case falls under that broad header. More specifically, it presents for our review challenging issues that arise from the Ludwell School Committee protocol, the protocol requiring its staff to use a student's requested name and gender pronouns within the school without notifying the parents of those requests unless the school student consents. So, if the child just wants to be called a different name or a different gender, this is in no sense something that the parent might want to learn about. This is in no sense something that might be something that needs to be brought to the parent's attention. And we say the student's request, but of course, where are they getting the idea from exactly? So is it really their idea in the first place? Right? But in any event, we're going to have we're going to have this privacy between the student and teacher. Student-teacher privacy confidentiality. I don't remember in my rules of evidence dealing with student-teacher privilege, but apparently that's a thing now. How exciting. Okay, our appellants are parents of the Ludwell student who chose at school but not at home to go by a different name and use different pronouns than those given to them at birth. Seems like something the parent might want to know about. The parents assert that Ludwell's practice of accommodating and concealing their child's requested name and pronouns while at school interferes with their parental rights as guaranteed by the U.S. Constitution. I mean, one would think the idea that parents have basically a right to raise their children on some fundamental level is fairly well established. And the idea that, the parents don't have to know, this doesn't fall into that category, though. Ludwell counters that the protocol is appropriate and necessary to ensure a safe and inclusive school learning environment for the students. Also, so that we can keep transing them and we don't have to tell you about it. It's just our little secret. I've also got candy in a van if you're interested in that. In this litigation, the competing concerns of parents and Ludwell raises heretofore unanswered questions about the scope of parental rights protected by the Due Process Clause of the 14th Amendment. But when all is said and done, we, like the district court, conclude parents have failed to state a plausible claim that Ludwell's implementation of the protocol as applied to their family violated the fundamental right to direct upbringing of their child. So again, the fact that the child wants to go by a different name and different gender and whatever is not interfering with the parent-child relationship, apparently, according to the First Circuit. Neat. All right, so let's go through the background a little bit further. As usual, our appellate work begins with an overview of the facts that give rise to the issues. As we jot through the procedural landscape, our recitation assumes the truth of all well-pled allegations of the complaint and draws all reasonable inferences in the parent's favor because this was dismissed out of hand, right? There was no trial because the court was like, even if everything you say is true, you lose, right? Failure to state a claim. Like, even if everything you say is true, it doesn't matter. So we'll assume everything the parent says is true because it just doesn't matter. Fun. All right. Baird Middle School is a public school in Ludlow, Massachusetts. Early in 2020-2021 school year, sixth grade students at Bard, including the 11-year-old BF, were given an assignment by the school librarian to create biographic videos about themselves. According to the parents' complaint, the librarian, Jordan Funk, encouraged students to include pronouns in their videos. Yeah, I mean, some subtle encouragement coming there from the teachers and the staff members. What are your pronouns? How do you feel today? What are the pronouns that best express your point of view? We're going to ask the child. That's exciting. The parent's complaint does not state how the student, designated female sex at birth, responded to the school assignment. You gotta love right away when the Court of Appeals says designated female sex at birth. Designated female sex at birth. As opposed as like this is just some arbitrary thing. This is just an arbitrary thing. They were designated female sex, but who knows what sex they would be? Who can say? Apparently not the doctor. Apparently that is not necessarily within a doctor's knowledge. But in the months that followed the assignment, the student's school's Google account started receiving unsolicited LGBTQ themed video suggestions on their school issued computer. Interesting. Oh, we're feeding them the LGBTQ videos somehow, mysteriously, just winding up on the school's computer. It's a mystery, I'm sure. After watching these clips, the student began questioning whether they might be attracted to girls and whether they had a gender identity issue. By December of 2020, the students sought out their teacher, Bonnie Manchester, to have a meeting to discuss some personal issues. At that meeting, the student indicated they were depressed and struggling with insecurity, low self-esteem, poor self-image, and perceived lack of popularity. The student told Manchester they needed help, but were unsure about how to ask their parents about getting help. Manchester offered to call the student's parents, and after reviewing the student's situation with other teachers during a school planning meeting and hearing other teachers agree the student seemed depressed, Manchester contacted the parents. Manchester told the student's mother, the appellant Marissa Silvestri, that the student felt depressed, was experiencing self-image issues, and may be attracted to members of the same sex. The 11-year-old, by the way, the 11-year-old. Okay. Silvestri was grateful Manchester reached out so Silvestri and the student's father, appellant Stephen Foote, could address the student's mental health issues themselves. To that end, Silvestri sent the following email in December 2020 to Bard's principal, Stacy Monette, the then superintendent of Ludlow Public Schools, Todd Gazer, members of the Ludlow School Committee, and all the students' teachers. So this parent has gotten contact by their school saying, we're a little concerned that your child is depressed. And the parent's like, oh, that's cool. I'm now going to send an email to the principal, the superintendent, and some members of the school to express to express some thoughts on this issue. Thank you. $5 Economath. If the parents go Gary Plouch on the magistrates and school officials that do support this stuff, I vote not guilty. Thank you for your super chat. Thank you, Alan Park, for the 20 gift memberships. And thank you, Claire Nystrom, from becoming an uncivilian. We do appreciate all your continued support. Okay, so here's the email that the mother sent to the school. It's been brought to the attention of both Stephen and myself that some of the students' teachers are concerned with her mental health. I appreciate your concern and would like to let you know her father and I will be getting her professional help she needs at this time. With that being said, we request you do not have any private conversations with the student in regards to this matter. Please allow us to address this as a family and with proper professionals, which, seems like a reasonable request, all things being considered, right? I mean, I want to get my child's psychological help from a licensed psychiatrist. I know that school teachers are cool and all, but not necessarily licensed psychiatrists. And I don't want you interfering in either this parent-child relationship or the doctor-patient relationship. I really don't want your interference as I'm trying to deal with this on my own time. So I'd really appreciate it if you not talk to the student about that. You can still talk to them about the curriculum and stuff. That would be fine. But if you could let them do their feelings with their doctor and me, their parents, I'd appreciate it. Cool. Unbeknownst to the parents, in February of 2021, email sent to the Baird teachers and school counselor Marie Claire Foley and Superintendent Gazda, the student announced, "I'm genderqueer." So now we've got an email from the 11-year-old to the school saying, "I'm genderqueer." Okay. According to the student's declaration, that meant the student would use any pronoun other than it, its, and also mean the students preferred a name change. They asked to go by R instead of B. Upon the receipt of the email and after meeting privately with the student, Counselor Foley learned the student was still in the process of explaining these identity developments to their parents, who incidentally might have their own thoughts about this issue, by the way. You know, if my kid came to me with these issues, accepting it as true would not exactly be my first impulse. I'd be like, "You're confused. You don't really know what you're talking about. You've been tricked by, society, culture, your student, your parents. Something has led you astray, probably taking you out of school and sending you to a different school because we need to get this corrected." So, but that's not the way that this school's going to roll. Anyways, pressing on with the story. Consistent with the students' requests, which apparently are superseding the parents, Foley directed the Baird staff to use the name B and she, her pronouns when communicating with the students' parents, but during school time to address the students as R. So when she's in school, she has an exciting school name, but we're not going to tell the parents about that. That's not important in any way, especially as the child is trying to undergo professional therapy. Following the directive, some teachers immediately started referring to the student as R and changed name tags accordingly. Funk, the school librarian, spoke with the student one-on-one about gender identity and provided the student with LGBT-related resources. How nice. The librarian is providing all these exciting reading materials to the student. The parents don't need to know what the child is reading. The parents don't need to have any idea what that is. That's not important. And Counselor Foley told the student that they could choose which bathroom to use, boys, girls, or gender neutral facilities at the school. And then there's a footnote here as well that's worthy of noting. There's a footnote that says the student's 12-year-old sibling attended Baird Middle School at the same time as the student we're talking about. So they have two children, one who's 12 and one who's 11. Around the same time as the above described events were playing out, the student's sibling also started using a name and pronoun different from those provided to the sibling at birth. Well, that's really interesting. Two siblings, both of whom are trans. That seems a little odd, given how rare transgenderism is in the overall population. Two siblings are both trans. That's a little weird. Though the parents allege that the Ludlow applied the protocol with respect to both children, the operative complaint provides scant details relating the specifics for the student sibling. We therefore concluded claim was not stated for the sibling and focus solely on the one student. So this other child also, but we're not going to talk about that right now. Okay, cool. All right. This is where the Ludlow protocol comes into play. To explain it and its implementation, though, behooves us to interrupt our narrative in order to provide the gentle reader with some important background about how the protocol came to be. What do you mean by gentle reader? What is the word gentle doing in this sentence? I mean, the word gentle is modifying the word reader. Why? What's the difference between a reader and a gentle reader? I'm not sure. But I feel insulted. I'm not sure that's what they're going for, but I feel like I'm being talked down to. Pressing on. In 2012, the Commonwealth Department of Elementary and Secondary Education issued non-binding guidance documents regarding gender identity issues. The guidance was published to help school districts comply with Massachusetts' then newly enacted statutory prohibition against discrimination based on gender identity in public schools. I really hope the federal government busts this all up using Title IX and other aspects of federal law, because this is some bullshit. The guidance contains policy suggestions for schools navigating issues related to gender discrimination. For example, when a student consistently asserts a particular gender identity, which incidentally, by the way, this isn't really consistent because it was the one time, right? It was the one email that says I'm genderqueer. So it's really hard to be consistent when it's the first, right? When, for example, a student consistently asserts a particular gender identity, the guidance recommends the school accepts the student's stated gender. This approach aligns with the Commonwealth statutory recognition a person's gender identity may be based on their identity, appearance, or behavior, rather than a person's psychology or assigned sex at birth. Again, there's that phrase, assigned sex at birth, or determined sex at birth, as though, again, it's an arbitrary thing. As though it's an arbitrary thing. You know, it's just a fashion. It's just a weird trope. Okay. The guidance also addresses potential conflicts between parents and students, noting that some transgender and gender nonconforming students are not open at home for reasons such as safety concerns or lack of acceptance. Maybe the parent's not really thrilled with this and doesn't really think that maybe the parent doesn't think that this is really what's going on. Maybe the parent has some concerns about this issue. The guidance suggests that school personnel should speak with the student first before discussing that student's gender nonconformity or transgender status with the student's parent or guardian. Again, let's keep a secret. Hey, kid, let's keep a secret. This is just you and me. This is just you and me. Just a little secret that we get to keep together. That's not creepy in any way. Consistent with the state's defense, suggested deference to the student. The document directs school personnel to discuss with the student how the school should refer to the student. That is, appropriate pronoun use in written communication with the student's parents or guardian. The recommendations reflect the general Commonwealth philosophy stated in the guidance that the person best situated to determine a student's gender identity is that student. Yeah, potentially with a little help from their teachers. Now to Ludlow and Baird Middle School, where the school committee and some individual defendants, like Superintendent Gazda, used the guidelines to establish and implement the protocol. The protocol is an unwritten policy that allows students of any age to determine whether their parents will be notified about decisions relating to affirming their own care. So this protocol that the school enacted wasn't a written policy. It was just a policy that was talked about in whispers, I suppose, in break rooms. This wasn't a written policy, which incidentally, of course, means that the parents had no way to know it's the policy of the school because it wasn't written down, right? They were never informed, like in a student handbook, by the way, here is a policy of the school relating to this issue. The policy of we're going to keep secrets from you was never told to the parents, which I suppose makes it more effective to keep a secret. But, you know, the parents had no way to know. And also, of course, it avoids the Freedom of Information Act or its state level equivalent because it also avoids discovery, right? I can't give you the policy that doesn't exist. It isn't written down anywhere. So that's nice. That's a nice trick. In other words, Ludlow protocol is one of non-disclosure. And they say this, by the way, they say it's one of non-disclosure, but they're okay with the non-disclosure, right? Instructing teachers not to inform parents about their child's expression and gender without that student's consent. As relevant here, the superintendent asserted the district's actions with respect to student complied with guidance and laws and regulations of Massachusetts. With the explanation of the protocol in the backdrop, let's get back to how things unfolded at Baird Middle School. Well, in early March, soon after the students sent their email to the staff, the parents learned about the student's alternative name from Manchester, the teacher in whom the student had initially confided. This discovery prompted the parents to speak with the principal and superintendent. In these conversations, parents expressed concern that Ludwell educators had disregarded the parents' December email, which provides specific instructions that school staff not engage with the children regarding mental health issues. As the parent complaint tells it, the school's recognition of the student's chosen name and pronouns constitutes a psychosocial mental health treatment because social transitioning, including assertion of chosen names and pronouns, is recognized as a medical health treatment for children with gender dysphoria. So the parent is like, this is a medical issue, at least in part, with the gender dysphoria and stuff. So you were defying me by treating my child medically in a way that I didn't approve of. Okay. Superintendent Gazda, in response, defended the educators who did not disclose the information about the student's gender identity. Under the law and regulation of Massachusetts, says Gazda, Counselor Foley and other Baird staff treat the student appropriately. No problems here. Baird educators continue to affirm the student's chosen name and gender. For instance, the parents noticed in April 2021 that one of Baird's teachers had mailed a card to the students and addressed it to RF, the student's newly addressed name, rather than the BF. And at that point, I would have stamped the thing, return to sender, no such name at this address. That would have been how I would have responded to getting this letter addressed to RF. Break out the stamp, return to sender, no such name at this address. Yeah. I don't know if I'm like the only one, but I do stamp the letters that I get from prior tenants at my apartment in the hope that it will, either inform the person mailing them to take them off the mailing list. I mean, most people probably just throw away letters that are for prior tenants, but I'm a nice guy. I actually take the time to stamp the envelope, return to sender, no such name, and put it back in the mail. I'm still getting mail from my prior tenant a year later, including from some of the people who have previously sent me letters. So I'm not sure it's working, but I'm trying. And throughout April and May of 2021, Counselor Foley corresponded with student via text message and online chat about gender identity, and further encouraged the student to meet with her weekly to discuss any gender-related concerns. In one chat message conversation, Foley asked the student if their parents were providing BF with appropriate care. In another discussion, Foley asked if the student was comfortable discussing issues with the non-school counselor chosen by their parents. Superintendent Gazda voiced his concern, or his support rather, for Ludwell's gender-affirming practices at the May 2021 school committee meeting, explaining the district policies fostered inclusion and sought to make schools safe for children, and also, incidentally, safe for predators. But that's probably less important. He added that under his leadership, Ludlow would continue to help children express who they are, despite parents' wishes to the contrary. Parents don't get a say here. He emphasized that for many students, school is the only safe place, and safety evaporates when they leave the confines of the building. Gazda reiterated his view that the school's approach adhered to Massachusetts non-discrimination laws and educational guidelines. Gazda explained that the district actions complied with the guidance In time, the parents sued the town of Ludlow and the Ludlow School Committee, as well as Gazda, Monette, Foley, and Funk in federal court, asserting 1983, "You've deprived me of fundamental constitutional rights under color of law." Their operative complaint chiefly alleges defendant conduct restricted their fundamental right protected by due process clause of the 14th Amendment, including the right to direct education and upbringing of their children, the right to make medical and medical health decisions for their children, and the right of familial privacy, all of which, incidentally, there is case law, of course, to support, including from the U.S. Supreme Court. So, like, they're not just making this up. There is case law on point, that parents have a right to direct their child's education. Parents have a right to make medical decisions. Parents have and there is also the idea of familiarity. Yeah. Economath says for $1.50, you can pay USPS to forward any mail you receive for them to general delivery and shift that headache onto the post office. I suppose I could. Well, actually, strictly speaking, I'm not sure I can. I'm not sure that I can create I'm not sure I'm legally allowed to create a mail forwarding if it's not my name. I'm not sure that's legal. So I'm not sure you're correct. I'd have to double check, but I'm not sure I'm allowed to do that. But thank you for the super chat anyway. The operative complaint chiefly alleges defendants' conduct restricted their fundamental parental rights protected by the Due Process Clause of the 14th Amendment of the United States Constitution, including the right to direct education and upbringing of children. Okay, we read that part. In response, defendant moved to dismiss the action under Federal Rule Civil Procedure 12b-6 for failure to state a claim. In a thoughtful rescript, the district court granted defendant's motion and, doing so, made several determinations. In short, as to count 2, it helped the parents had failed to allege that Ludwell's conduct involved medical treatment. I did it for prior owners of my homes and had no problems. But was it legal, Economath? Was it legal? I didn't say it didn't work. I didn't say it wouldn't work. I said, is it legal? Christ, listen more carefully. Damn. As for the remaining claims, the court concluded more broadly that parents had not alleged the sort of conscious shocking conduct required by Supreme Court precedent to establish a substantive due process violation. The court went on to hold that even if parents could state a substantive due process claim, the individual educators would be entitled to qualified immunity. The parents dissatisfied, the appeal followed, and we are here. We reviewed the district court's 12b-6 dismissal of the parents' complaint de novo. In undertaking this task, we were reminded that we're not bound by the district court's reasoning, but rather may affirm on any ground may manifest by the record, which is true enough as far as it goes. Of course, these are legal questions. So as to what the law is here, that all the rest of it. Mike Middleton for California or Canadian 279 says, would this now allow for conversion therapy? Perhaps it would allow for conversion therapy. Perhaps that, all those things too. That would be fine. Anyone who thinks you can turn a person trans is not playing with a full deck, well, I certainly think you can. I think that trans is a social contagion. I think that a lot of people are being convinced that they're trans based on social contagion. And the idea of social contagion creating basically mass psychosis is something that is well known in history. And not only, of course, as it relates to transing, but all kinds of things. People have gotten sick, including mass people have gotten sick merely from believing it. So you can absolutely cause yourself to become ill, physically ill, with serious symptoms, merely from psychosis. And so, yeah, the mind is a powerful thing. And so I absolutely believe that you can trans somebody, especially when they're young and particularly impressionable and they're confused as they might be going through puberty, which is an inherently traumatizing and difficult time in someone's life and might be having strange feelings. Yeah, I think the power of suggestion goes a long way. I think all those things. So that's what I think. Out of the starting gates, It can also be a real thing. I don't know if you're responding to me or the other guy, but if you're responding to me, once again, failure to pay attention. I was responding to a guy who said, what was the quote? I was responding to a guy who said, anyone who thinks you can turn a person trans is not playing with a full deck. So my response was based on the premise that you can't turn a person. And I'm like, yes, you can. That isn't to say that it isn't something that could exist as a result of nature. Although I potentially quibble with that, but that isn't what I was responding to. So you're responding to a point I wasn't raising, which is slightly frustrating. Out of the starting gates, we reasonably begin by getting out of the constitutional law bearing on the 14th Amendment due process clause doctrine at play here. The doctrinal provision states that no state shall deprive any person of life, liberty, or property without due process of law. And as our judicial superiors repeatedly tell us, that would be the U.S. Supreme Court, incidentally, by this time, it uncontrovertibly protects against government interference of both procedural and substantive rights. Elaborating on those safeguards, the Supreme Court has held for nearly 100 years. The Due Process Clause explicit promise of liberty ensures certain fundamental rights. Pertinent among these substantive liberty interests is the right of parents to make decisions concerning the care, custody, and control of their children. So, as I said, this is something the U.S. Supreme Court has said. And then they say, see also, Pierce versus Society of Sisters, 1925, the right to direct the upbringing, education of children. Meyer versus Nebraska, great case, by the way, really cool case. I like Meyer versus Nebraska. The right to bring up children. Meyer versus Nebraska related to a teacher who wanted to teach German. And there was like, can I teach the German? And that wound up at the Supreme Court. Ordinarily, to determine whether some governmental conduct has violated substantive due process rights, courts must undertake, as their precedent directs, a layered inquiry. It begins by asking whether the challenged governmental conduct is legislative or executive in nature. We ask that question because the answer to it directs which analytical pathway we must follow and what level of scrutiny will be applied to determine if the parent's due process rights have been violated. Let's begin. I'm excited to begin too as well. I'm also excited to begin. All right, let's go. Executive or legislative conduct. Categorizing governmental conduct as executive or legislative is not necessarily an easy task, particularly when the boundary between two is not always well defined and when some governmental conduct can even straddle the line. As has been observed, sorting these close calls requires an eye for function, not form. In that vein, sometimes the inquiry is simple. In most cases where a substantive due process challenge is brought, we see that statutes and governmental policies are typically deemed legislative. Indeed, statutes are plainly legislative. Well, thank you for clarifying that. On the executive conduct front, individual acts of governmental officials are often and ordinarily executive in nature, untethered from any policy. Well, I don't know if it goes so far as to untethered from any policy. It's just the policy is political, but it doesn't necessarily mean there isn't a policy. Okay, and then they cite some cases where they say treating as an executive action the forcing pumping of a suspect's stomach, and then applying the conscious shocking test when a state employee was alleged to have committed sexual assault. $5 from Tina and the World. There's a reason gender dysphoria is in the DSM-5, because they're confused about gender. That much is true as well. Thank you very much. The same has been deemed true for concerted actions by mobile governmental employees, if taken pursuant to broad governmental policy. Such actions are closer to legislative conduct. Okay. And then apparently there's a case where they declined to apply the shock the conscience test when they challenged the FBI's no-fly list, which was an executive policy akin to legislative acts. I don't know how that's akin to a legislative act when the FBI has a policy about a no-fly list. I don't know how the FBI's implementation qualifies as a legislative act. That sounds odd to me, but okay. Challenges to executive versus legislative conduct garner different judicial examination. For substantive process challenge for an executive action to proceed, the conduct must first satisfy the shock the conscience test. No, that doesn't sound right. For a substantive due process challenge for executive action to proceed, the conduct must satisfy shock the conscience. No, that's wrong. That's wrong. Shock the conscience is certainly sufficient, but is not necessary for a substantive due process violation. I mean, it could just be because it's arbitrary or capricious, which doesn't necessarily mean it shocks the conscience. It could be because it's unequal protection. I don't think it has to be shock the conscience. That doesn't sound right to me at all. So that doesn't sound right at all. That sounds wrong. The test asks where a behavior of a governmental officer is so egregious, so outrageous, why is there a redaction in a footnote for a citation? Why is there a redaction in a footnote when we're citing precedent? The footnote says, to round things out for the curious reader, Lewis, which is obviously a prior case, taught that the touchstone of due process is protection of the individual against arbitrary actions of government. And then they delete a cite. And only the most egregious official action can be said to be arbitrary in a constitutional sense. Yeah, I've never seen a citation to precedent put in a redaction. That doesn't make any sense. Let us look it up, because that's a first, man. I can't imagine why you would redact a precedent from the U.S. Supreme Court. U.S. Supreme Court decisions are secret now? Okay, that's interesting. Let me pull it up. All right. So this is 833, 847, note 8. Okay. That's easy enough to look up. All right. 847. Okay. 847. Note 8. Well, oh no. See also DuPont at 11. Well, I have to do a search now to figure out where this is coming from. Okay. Touchstone. Okay. The Supreme Court said, we emphasize time and again the touchstone of due process is protection of the individual against arbitrary action of government, whether the fault lies in a denial of fundamental procedural fairness or in the exercise of power without any reasonable justification in the service of legitimate governmental function. I don't begin to understand why this is redacted. That makes no sense to me. Okay, that's really, really weird. That's a first. I've never seen that before, man. That is a first. Challenges to executive versus legislative conduct, gender different examination. We read that part, and I'm like, yeah. Search for quoting. No, that's the quoting isn't. It's quoting Wolf versus McDonald. Which is also the U.S. Supreme Court. Yeah. So I don't know why you would redact that. I mean, I can look up Wolf versus McDonald too. I just don't know why you would. Yeah, I mean, Wolf versus McDonald is a 1974 case dealing with disciplinary procedures in a prison relating to mail. Okay. I mean, you know, okay, I guess. I don't know that one. That doesn't make any sense to me. Only if the executive conduct does shock the conscience will the analysis move on to substantive due process framework, next stage. On the other hand, legislative conduct, like a statute, regulation, or governmental policy of any kind, need not be conscience shocking for further judicial inquiry to occur. I don't think they're right about this conscience shocking test. That just does not sound right. Rather, courts proceed directly to the next layered step of the substantive due process framework, asking whether a fundamental right is involved and whether governmental conduct restricts that fundamental right before moving on. And there's more redactions. Can I request an unredacted document from the court? Why would I do that? I know what they're hiding. It just doesn't make any sense that they would redact it. Econo amount for $5. Just check, not illegal. Okay. Let's find out. All right. So this is mail change of address, right? You're doing a mail change of address. I request the unredacted document to explain why it was redacted. I don't really fucking care. You can do it if you care. How about that? You can file your the form if you care. I don't really fucking care. It's just really weird. Yeah. So for a change of address, who can file change of address? Who can file change of address? The person who submits change of address form states that he or she is the person, executor, guardian, authorized officer, or agent of the person for whom the mail would be forwarded under this order. So you broke the law. You broke the law. because you are not the person, executor, guardian, authorized officer, or agent of the person for whom the mail would be forwarded. So you violate the law. You looked up the law wrong and you violate the law. Good job. The general executive versus legislative parameters noted, we get back to the case and what transpired below. Policies are not always the law. Well, if it's an official regulation of the post office, then it's in the Code of Federal Regulations, and yeah, because that would be a violation of the law. So it's a violation of the law. I mean, it says right here, individuals may not file a COA request for someone other than themselves or a business without authorization. I mean, I don't know how much clearer it can be in the regs. So you broke the law. The general executive versus legislative parameters noted, we get back to the case and what transpired below. When the defendant's motion to dismiss came before a district court, the court did not undertake the initial executive or legislative inquiry. Instead, it followed the party's lead and treated the protocol as executive action, thus examining whether Ludwell's actions were so egregious as to shake the conscience. The court then reasoned that Ludwell's conduct was not so extreme, egregious, or outrageously offensive as to shock the conscience. But by our light, the district court, in following the party's lead, jumped the gun and not analyzing the type of governmental conduct involved. Throughout all the roads in the end still lead to Rome. In our de novo review, we conclude the shock the conscience test was not the appropriate legal standard to utilize here in examining the parents' claims, because the parents are challenging a school policy, which after careful scrutiny of the policy involved, we conclude is legislative, not executive conduct. In our assessment of the precedent as between legislative and executive conduct, as between the protocol better fits into the legislative bucket. We so conclude because it's a policy which applies broadly to all students in the Ludwell School District and is administered by multiple governmental actors. And although the parents challenge some individual actions of Ludwell educators, for example, the complaint objects to teachers discussing gender identity with students, providing gender identity resources to some students, and allowing gender students to use the bathroom of their choosing, those discrete decisions by individual educators were actively implemented by the protocol. The town name is Ludlow. Ludlow? Yeah, that makes sense. Accordingly, with legislative conduct box ticks, we proceed to the next phase of our substantive process analysis and ask where parents have adequately alleged that Ludlow's conduct restricts a fundamental right. The parents say yes. They claim Ludlow's conduct restricts the parents' right to uphold the upbringing, custody, education, medical treatment of their child. Our job in resolving this contention is twofold. We must first determine whether parents have identified a right recognized as fundamental, and so we must examine whether the parents have sufficiently pled that Ludlow's conduct did indeed restrict that right. What state is this? Well, Massachusetts, but more directly the entire Northeast, because it's the First Circuit. Also Puerto Rico, because Puerto Rico is next to Maine, don't you know? All right. So Puerto Rico, Maine, Massachusetts, and Vermont, and the rest of New England. Yeah. Puerto Rico and the rest of New England, yeah. Our guiding light in this realm is a trio of Supreme Court parental rights: Meyer versus Nebraska, Pierce versus Society Sister, and Toxel versus Gainville. Those cases define the parental right broadly as a fundamental right to direct the care, custody, and upbringing of one's children. These rights are perhaps the oldest of the fundamental liberty issues reflected by the court. The Supreme Court has made clear more than a century ago that due process gives parents the right to bring up children and control the education of their own. When we drill down on the Supreme Court's teachings, we observe the Supreme Court parental rights cases have never described an asserted right by preference to the specific conduct at issue. Well, no, they didn't describe it with respect to the specific conduct at issue. That's true. They're like, parents have a right to control their education and raising their kids. And they're like, well, you didn't say specifically that we can't trans the kids. Give me a break. Meyer did not define parents' asserted liberty interest as the right to allow their child to learn German before the 8th grade. Nor did Pierce describe the parental interest at stake as the right to send one's child to a religious school. And Toxel did not define the right at issue as the right of a parent to prevent a grandparent from visiting one's grandchild. Rather, in each of these decisions, the court instead considered whether the conduct at issue fell within a broader, well-established parental right to direct the upbringing of one's child. Right. So this is a broader right, and these are specific examples of a broader right. Right. So the right isn't exactly to determine who can visit your kids. Right. So it's like the grandparent wants to visit, and I'm like, how about no? And I get the ability to make that decision as the parent. But it isn't exactly speaking my right to prevent the child's grandparent from visiting. That's not exactly right. Rather, the right is to control the upbringing of my child, and that's merely an example of the right, not the right itself. Which, fair enough. We necessarily follow that approach in the instant matter and thus decline to define the right at issue with microscopic granularity. Well, you're not supposed to define the right with microscopic granularity. You're merely supposed to decide whether or not this thing falls within the broader example. So with that guidance in mind, we conclude that parents have identified a fundamental right in their complaint with sufficient specificity. But as noted, our inquiry does not end there. Notwithstanding the parents' adequately pled rights, we still must determine whether the parents have sufficiently alleged that Ludlow engaged in conduct that actually restricted those fundamental rights. Here, the parents argue that Ludlow's conduct restricted their substantive due process rights in 3 ways. Ludlow's performed medical treatment on the student through accepting the student's social transition without parental consent. Ludlow facilitated the student's social transition to alternate genders via curriculum and administrative decisions without parental consent. And Ludlow implemented the protocol which deprived the parents of information about the student's expression of gender. We address each in turn, evaluating whether the parents' claims are plausibly alleged to be in line with the broader principles set forth by the Supreme Court's substantive due process canon. We begin with the parents' allegation that Ludlow conduct restricted their fundamental right to direct medical treatment for their child. To repeat, parents do have a fundamental right to make decisions concerning care, custody, and control of their children. That right includes parental right to seek and follow medical advice concerning one's children. Ludlow, the parents alleged, socially transitioned their child to a new gender and identity by accommodating their child's request to use a new name and pronouns at school. And the parents contend that because social transitioning is recognized as medical health treatment for children with gender dysphoria, Ludlow was implementing a psychosocial treatment on their child. The parents conclude because Ludlow indicators performed a psychosocial treatment without parental knowledge or consent, Ludlow usurped the parents' fundamental right to direct medical treatment for their child. The district court dismissed the claim because the parents provide only conclusory statements describing their use of preferred names and pronouns as mental health treatments. The parents, for example, failed to allege that Ludlow's use of students' requested pronouns involved a treatment plan of any sort. The district court, setting aside the conclusory allegations of the parents' complaint, held that the parents had not adequately pled that Ludlow usurped their right to make medical and mental health treatments. We agree with the district court. Although the parents describe the decision made by the educators as mental health treatment, their labeling, without more, cannot transform the conduct into medical intervention. So despite the fact that this was recognized in the DSM with gender dysphoria, them recognizing the name and like leaning into it is not medical or medically implied. Yeah. Eric in chat says, like a vegan cat, these decisions are not being made independently. I tend to agree, Eric. I tend to agree. Yeah, it's not really the kid that's really making the decision. Not really. Kurt's instilling scare tactics? I don't think so. I think my video title is an accurate description of the situation at hand. In my opinion, I believe it's an accurate description. If you disagree, fuck off. Fucking off is always an option. The parents allege, for example, that Ludlow's educators spoke in private in their child to promote exploring and experimenting with alternative or discordant gender identities and facilitate their gender affirming social transition. I'm a scaremonger? All right, well, I'm banning you. Bye. If you won't fuck off, I'll help you fuck off. There's the door. Don't let it hit your ass on the way out. But on the appellate record, we're unconvinced that merely alleging Ludlow's use of gender-affirming pronouns or gender-affirming names suffice to state a claim the school provide medical treatment to students. In fact, while the Supreme Court has never specifically defined the scope of parental right to direct her child's medical care, the parents fail to state a claim because the allegations as stated do not suffice to describe medical treatment at all. At all. It's not medical treatment. That's interesting. Okay. The Ling Supreme Court decision on parental control medical care involved a child's institutionalization, that's the right word, institutionalization at a mental health hospital. The Sixth Circuit decision in Kowarski versus Michigan suggests that state actors' retention of blood samples from children without parental consent violated substantive due process. And the 10th Circuit in Dubs suggests that government-funded preschool programs violate parents' right to direct their children's medical care when a nurse performed physical examinations and blood tests on children without notice or consent. Each of these cases involve intrusions upon bodily integrity of the child or other conduct with clinical significance, whether through medical procedure, examination, or hospitalization. Thus, although precedent indicates that parents have a right to direct their child's medical treatment, whether that treatment is complex or more routine, the allegations do not involve clinical conduct at all. Well, they may not involve clinical conduct as such, but to say that there's no medical implications, I think, is wrong. So I think they did a little linguistic trick right there, right? It's like, oh, they have a right to direct medical treatment. This isn't clinical. Well, I suppose it's not a clinic. I suppose that's true, but that doesn't mean that it doesn't have medical implications. In fact, the fact that it's not clinical is in some senses the problem because you're not a doctor. That's kind of the problem. So yeah. These rulings increase your blood pressure. They increase mine too, man. And I am tired of this gender bending activism and, you know, these ideas that make no sense. You know, I was watching a hearing in Congress. I'm not sure when the hearing happened, but there was a man there who believes they're a woman who's a medical doctor, and so the congressperson asked the would-be woman, like, are you a woman? She says, the person says, I'm a trans woman. And so the congressman asks, do you have a penis? And that caused the person to completely, like, you know, throw a hissy fit and all the rest. How dare you ask me that question? How dare you ask me whether or not I have a penis? There was a whole to-do about it. It was dumb. All right, curricular and administrative decisions. The parents also claim that the actions of Ludlows, teachers, and staff restricted their parental rights by facilitating the students' gender-affirming social transition. They cite librarian Funk's request that students state their pronouns as part of an academic biographical video assignment, the teacher's use of students' requested name and pronouns at school, Counselor Foley's permitting the student to use the bathroom of their choice, and Foley's discussion of gender identity-related concerns with students. The parents allege that these actions taken without knowledge or consent restrict their fundamental right to direct the upbringing of their child. The measures the parents cite, however, all involve decisions by the staff on how to reasonably meet diverse students' needs within the school setting. What a nice euphemistic phrase, right? What a nice euphemistic phrase. This is just meant to meet diverse students within the school setting. The Supreme Court has never suggested that parents have a right to control a school's curricular or administrative decisions. Rather, the parental rights more essentially provide the state cannot prevent parents from choosing a specific educational program. The parents may wish to change the school. That might be a good idea. I'll tell you what, man, if I ever have kids, I'll tell you what, at a bare minimum, we're going to a school in a heavily red Republican county. Bare minimum, right? And then we'll work from there. Meyer, for example, struck down a Nebraska statute prohibiting the teaching of foreign languages in part because the law interfered with parental rights to procure such instruction for their children. And Pierce invalidated an Oregon law requiring parents to send their children to public school between the ages of 8 and 16. In both cases, the state had barred parents from enrolling their children in a particular educational tract. Yet neither Meyer nor Pierce undermines the state's power to prescribe a curriculum for the institutions which it supports. We've consistently applied the principles in rejecting parental control over curricular and administrative decisions. In Parker, for example, the plaintiff parents claimed a right to be given prior notice by the school an opportunity to exempt their young children from exposure to a book they found religiously repugnant. Two books at issue portray diverse families, including families in which both parents were of the same gender, while another book depicted and celebrated gay marriage. In rejecting the parents' substantive due process claim, we know that no federal court had ever held the due process clause permitted parents to demand an exemption for their children from exposure to certain books used in public schools. We conclude that once parents choose to send their children to public school, they do not have a constitutional right to direct how a public school teaches their child, which is probably true as far as it goes, but it's overextended here. Likewise, in Brown, we considered a high school's failure to notify parents of their ability to exempt their children from sex education presentation. Those parents sued, claiming the school's inaction, restricted their substantive due process rights to direct the upbringing of their children and educate them according to their own views. In rejecting the parents' claim, we explained that Meyer and Pierce protected against the state prescribing parents from educating their children, not situations in which parents seek to prescribe what the state should teach their children. In doing so, we emphasize that schools need not cater a curriculum for each student whose parents have genuine moral disagreement with the school's choice of subject matter. The parents' objections here are no different. I mean, I think they're a little bit different. At least in a sex education case, you are teaching them about, biology. You're teaching them about rooted in biology. And you're teaching them about facts. Here, transgender is not rooted in any cohesive scientific principle that I can identify, or neither can the left, incidentally, because they can't even define what a woman is. They can't define it. It's like, you should listen to women. Great. What are they? Cricket noises, right? Cricket noises. How would I know if the person speaking is a woman or not? Can you tell me? And they'd probably say, you can ask them. I'm like, okay, so let me make sure I understand this correctly. In order to determine whether or not I'm supposed to listen to any particular person, I have to ask every single person what their gender pronouns are. That's now required in every single conversation. Okay. Cool. Also, homeschooling is a lot easier these days, especially with virtual schooling. So that's nice. Technology gives and it takes away. And one of the things that makes available is homeschooling is a much more practical option because there's now virtual schooling. And so you can basically attend school online. And so that helps a lot with many issues. So it's nice. The parents' objection here are no different. I think they're a little different. To the extent, and thank you, by the way, for the 350 of you who are here. I appreciate you spending some time with me as we go over this case in detail. Don't forget to hit that like button. It does help with the algorithm, particularly on cases like this, because YouTube doesn't really like me talking about this kind of thing, as I'm sure you can appreciate. So if you want me to continue talking about these kinds of things, what would really help a lot is you liking the video, because that will help with the algorithm and help to counteract some of the algorithm. And also leaving a comment in the comment section would really help. And plus, since my ad revenue is probably going to hell, I'd appreciate if you gave me some super chats. That'd be nice. Was I homeschooled? No, I was not homeschooled. But I'm just saying it's easier. It's easier now than it used to be because of virtual schooling. I don't know how that's relevant to anything, but cool. And I'm not necessarily saying that public schools can't be good. As I said, I'd want to live in a heavily Republican district, so that so my kids could potentially attend a school that isn't, woke batshit nuts. So attending public school might be a perfectly viable option in many situations, maybe most situations, but not necessarily all because of bullshit like this. Through the €5, Mace Windows says, please continue talking about the issues. It's refreshing. Thank you. And I think it's important to read these legal decisions as well in detail so you can see this thinking. And this represents the thinking of a lot of people out there. And some of them are judges, and some of them control now, and some of them have just written a decision that now controls the entire Northeast corridor of the United States. Though the parents in Parker and Brown specifically challenged curricula, our rejection of those claims recognize the broad discretion of schools to manage academic and administrative functions. Indeed, whether the school curriculum, the hours of day, school discipline, timing, and content of examination, the individuals hired to teach at school, the extracurricular activities offered at the school, or dress code, these issues of public education are generally committed to the control of the state and local authority. Because public schools need not offer students an educational experience tailored to the preference of their parents, the Due Process Clause gives the parents no right to veto the curricular and administrative decisions identified in the complaint. We now come to the parents' challenge of the Ludlow non-disclosure protocol. As alleged by the complaint, the protocol provides that parents are not to be informed of their child's transgender status and gender-affirming social transition to a discordant gender identity unless the child of any age consents. The protocol, the parents argue, restrict the right to direct the child's upbringing in that deceives them, and doing so deprives them of information about the student. But as will impact the parents' challenge here fails. For starters, the Ludlow protocol of deference to students' decision about whether to disclose their gender identity to their parents lacks coercive, or restraining conduct that other courts have found to restrict parental rights in this conduct. Okay, I mean, I guess I don't know about that, but all right. In Arnold versus Board of Education, for example, the 11th Circuit held that school officials violate parental rights by coercing a minor into having an abortion and concealing the decision from her parents. That sounds like not great. You know, that doesn't sound great. The school coercing a kid into having an abortion and then hiding it from their parents sounds a bit problematic. There, a school counselor demanded that a student have an abortion, and school officials provided the money and transportation necessary for the procedure. Wow. Wow, that's a lot. And unlike Ludlow's deference to students, school officials in Arnold coerced the minor to refrain from consulting with their parents. Here, by contrast, there are no allegations of coercive conduct towards the student. The parents object to Ludlow's employees sharing resources about gender expression and to the resources. That would be the literature and the books and stuff. Yeah, the resources. And to the messages from Counselor Foley to a student asking if the parents and parents counselor are providing adequate care for the student. But providing educational resources about LGBTQ related issues to a child who's shown interest imposes no more compulsion to identifying as genderqueer than providing a book about bricklaying could coerce a student into becoming a mason. Well, that is one of the more disingenuous sentences I've ever read in my life. Howie Brown gifted 20 gift memberships. Yeah, so providing these books, literatures, pamphlets, and stuff are non-coercive because it wouldn't be coercive if they gave him a book about bricklaying. Uh-huh. That's some bullshit. Economist says, still not illegal. I can easily argue agency under either implied authority or ostensive agent in reasonable furtherance of a home purchase. No, you can't. It is illegal. And you're beginning to fucking piss me off. You're beginning to fucking piss me off. I took the time even to look it up. I took the time on my stream to divert myself from the stream to double check what you said because it didn't sound right to me. I took the time to double check it, look it up, and now you're still fucking arguing with me and you're fucking pissing me off. If you don't value my legal input, if you don't value my legal opinion, I don't know why you're here. Nor are chat messages coercive, even when viewed in light most favorable to parents. Those messages cannot be reasonably viewed as strong arm statements. Rather, they are essential questions from the school counselor trying to assert the well-being of a student. The parents, however, also claim that Ludlow deliberately deceived parents by continuing to refer their child by their birth name and pronouns in presence of their parents while using the child's preferred alternative name and pronouns at other times. Viewed in the light most favorable to the parents, the allegation arguably challenges a restricting act by Ludlow, that is, deceptive communication to the parents. I mean, that sounds problematic. The deceptive communication sounds problematic to me. The theory of affirmative misrepresentation is unavailing here. The complaint contains only general allegations that under the protocol, Ludlow educators were directed to intentionally misinform and lie to the parents about the student's requested name and pronouns. But as the parents contradictorily states in their complaint, when a teacher mailed a card to a student at home, it was addressed to RF, the student's newly identified name, not BF, which is probably a mistake, incidentally. It was probably a mistake. So I'm not sure that them sending the name really I'm not sure that's contradicting so much as, indicating it's still happening. And no allegation suggests that when parents tried to speak with school officials about the student, the officials misrepresented the name the student had chosen for in-school use. Rather, the officials, beyond Manchester's communication with parent, just declined to discuss the student's gender identity issues with parents. So that's the same thing, just merely trying to describe it. I think Beyond the theory of affirmative deception, the parents also mount a challenge to withholding information about a school's expression of gender while at school. But this non-disclosure angle similarly does not state a constitutional deprivation. That's because it's clear from precedent that attempting to establish a constitutional deprivation of this sort, it's not enough for parents to allege the non-disclosure protocol makes parenting more challenging. The guarantee of substantive due process limits the state's power to act by forbidding governments from depriving individuals of life, liberty, or property without due process of law. Yet the Supreme Court has made clear the due process clause cannot fairly be extended to impose an affirmative obligation on the state to ensure that those interests do not come to harm through other means. As other circuits have concluded, this limiting principle applies to parental rights. In Anspach, the parents of a 16-year-old girl sued a city-run health center that provided their daughter with emergency contraception medication, alleging the facility violated their substantive due process right to family relations. The center, according to the parents, not only failed to encourage the minor to consult, but even intended to interfere and to influence the minor to refrain from discussing with the parents the possible pregnancy. And more broadly, the parents alleged that the center's policies were aimed at preventing parents from learning of their minor daughter's possible pregnancy. The Third Circuit rejected the parents' claims because there's no constitutional obligation on state actors to contact parents of a minor or to encourage minors to contact their parents. In elaborating, the court observed the real problem alleged by the parents was not the state actors interfered with them as parents, but it was the state actors did not assist the plaintiffs as parents or affirmatively foster that relationship. A cognizable parental rights claim under due process, the Third Circuit explained, generally requires restraining conduct by the government, not mere non-disclosure of information. The court held that the health center engaged in no such conduct because it did not prevent the minor from calling their parents before she took the pills she had requested. Although the parents' moral and religious sensibilities may have been offended by their daughter seeking out emergency contraception, her decision was voluntary, as a minor, incidentally, of course. Thus, because the due process clause does not protect parental sensibilities nor guarantee a child will follow their parents' moral directives, the parents' constitutional rights were not restricted. The Sixth Circuit adopted a similar view of parental rights under a due process clause in Doe versus Irwin. There, parents of a minor child sued a publicly funded family planning clinic, alleging the clinic's distribution of contraceptions to minors without parental notice violated their rights. The district court, when enjoined that practice, held that the clinic interfered with the parents' fundamental rights because the parents were prevented from being made aware of the actions of the state-run agency which facilitated the situation inadmissible, to the values of the parents were attempting to teach the children. The Sixth Circuit reversed, explaining the Supreme Court's parental rights cases, such as Meyer and Pierce, each involved situations where the state was either requiring or prohibiting some activity. The clinic, in contrast, never required the children of the plaintiffs avail themselves of the services offered, nor did the clinic prevent the parents from participating in decisions of the minor children on issues of sexual activity and birth control. In fact, the parents remained free to exercise traditional care, custody, and control over their unemancipated children. The bottom line was the practice of not notifying the parents of their child's voluntary decision did not deprive the parents of their protected liberty interest. Here, too, the challenged governmental action merely instructs teachers not to offer information of students' gender identity without student consent. In the instant matter, parents remain free to strive to mold their child according to the parents' own belief, whether through direct conversation, private educational institutions, religious programming, homeschooling, or influential tools. They say that now, by the way. They say that now the parents remain free. But you bet your ass, and to some degree, we've already seen decisions from this in some family courts, right? It's like if you try to actually take your child and put them in a place where they won't be taught the wrong thing, that's child abuse. That's child abuse, and child services will be called. So they say parents remain free, but do they? Do they, though, remain free? And not at all clear. Not at all clear. The parents disagree these alternatives suffice to protect their rights. They allege the protocol impermissibly infringes on their ability to use methods to guide the upbringing of the student because they are denied important information about the student's gender. But the protocol operates only in the school setting, where, as we've explained, Parents have less authority over decision-making concerning their children. Outside school, parents can obtain information about their child relationship to gender in many ways, including communicating with their children and making meaningful observations about the universal circumstances that influence their child's preferences, such as in clothing, extracurricular activities, movies, television, music, internet activity, and more. To be sure, knowing that students have requested the use of alternate name and pronouns in school might inform how the parents respond to and direct their child's gender expression. You think? You think it might help? In all likelihood, the students' lack of consent to share their in-school gender choices with their parents might mean they'd be cautious outside school to avoid signals that might disclose their choices. The children remain completely free to make choices, I suppose, in this context. Indeed, we're sympathetic to the parents' interest in having, are you sympathetic though? Are you? Indeed, we're sympathetic to the parents' interest in having as much information as possible about their child's well-being and behavior in the school revealed to them. Nonetheless, as we've explained, our survey of due process clause jurisprudence suggests this does not require governments to assist parents in exercising their fundamental right to direct the upbringing of their children, and parents' objection to the protocol here in part take issues with the principles we understand them to be. In any event, as the complaint makes clear, the parents did learn from school staff about the students' use of different names and pronouns within days of changes and discussed those changes with leadership. In this as-applied challenge, we conclude the allegations in the complaint about how the protocol was implemented did not restrict any fundamental parental rights. Yeah, I mean, I don't really think so, and I think there's a reasonable chance the Supreme Court might take this up. I don't know if this is necessarily as clean procedurally as they necessarily would want it to be, but it's not the worst vehicle I've ever seen. So as a vehicle for raising these issues, it's sufficient at least. So I think there's a chance the Supreme Court takes this up. Maybe. Let's regroup. We conclude that parents have not plausibly alleged that Ludlow's conduct restricted a fundamental right. Be that as it may, the conduct still must withstand constitutional scrutiny. Namely, in view of our no restricted fundamental right conclusion, the conduct must survive rational basis review. Under that deferential standard, we presume the challenge conduct is valid so long as it's rationally related to a legitimate state interest. In performing rational based review, we consider only where the state could have reasonably concluded the challenge conduct might advance legitimate interests, and ordinarily the reasoning that in fact underlay the decision is constitutionally irrelevant, right? So we'll look at, under rational basis review, we'll look for any reason that would sustain the government's action. It need not be the reason the government stated. If the government did state a reason, if that reason doesn't work, we'll supply one of our own. That's true enough as far as it goes under rational basis review. But the problem isn't the rational basis of the policy. The problem is the conflict with the parental rights as that was detailed. So the policy is rationally based as far as it goes, but it conflicts with another principle. That's more the problem. However, some objectives, such as bare desire to harm a politically unpopular group, are not legitimate state interests. Ludlow asserts an interest in cultivating a safe, inclusive, and educationally conducive environment for students, which allows students to thrive and learn. The parents insist Ludlow exceeds the bounds of legitimate pedagogical concerns and usurps the roles of the parents to direct the upbringing of their children. But in reasonable due deference to Ludlow's articulated policy rationale and based on asserted interests, we conclude Ludlow's conduct is rationally related to its legitimate stated interests, and thus the protocol survives rational basis review. State actors have a compelling interest in protecting the physical and psychological well-being of minors. That interest is at its apex when a school board seeks to protect children who are particularly vulnerable, such as transgender minors. Here, we refer to the Commonwealth's investigation findings, which suggest that though many parents are supportive of children's expression of gender, it is not uncommon for students exploring their gender identity to fear parental backlash against their choices. Not for at least the reasons it's not necessarily the child's choice. It's not necessarily the child's choice. So, yeah. The protocol plausibly creates a space for students to express identity without worrying about potential backlash, or parental backlash rather. By cultivating an environment where students may feel safe in expressing gender identity, the protocol endeavors to remove psychological barriers for transgender students and equalizes educational opportunities. In sum, the protocol bears rational relationship to the legitimate objectives of promoting safe and inclusive environment. Rational review requires nothing more. And as to that much, the court is right? As to rational basis review, they're correct. So, yes, the policy is probably correctly reviewed under rational basis review. That sounds right. But that's not the problem. The problem is not the rational basis review. The problem is that it's conflicting with the rights of parents to raise their children. That's more the problem. So, yeah. Here's where this all leaves us. As this opinion has endeavored to illuminate, we acknowledge the fundamental importance of rights asserted by parents to be informed of and directed to significant aspects of their child life, including their socialization, education, and health. If you acknowledge that, how are you getting to where you're getting? Court, right? They say we acknowledge. Whoa, sorry. Let's try a different color. They say we. Fine, I guess highlighting is out. We'll do a line. God damn it. How about this? Is this good for a line? There you go. We acknowledge the fundamental importance of the rights asserted by the parents to be informed of and direct significant aspects of their child's life, including socialization, education, and health. Yeah, do you though? Do you acknowledge that? Because if you acknowledge that, what are we talking about? Be that as it may, this opinion has also made effort to explicate parental rights are not unlimited. Yeah, that's true. And that kind of writing always kind of pisses me off a little bit. I don't really like that in Second Amendment writing either as well. I really don't like it when courts say the rights aren't unlimited, because the next thing they inevitably say when they write that is they say, well, this isn't covered because rights aren't unlimited. I'm like, that's really dumb. That's dumb. That's a dumb way to think. That is a dumb way to think. Just because rights are unlimited doesn't mean that this isn't a right. Yes, it's true the rights aren't unlimited. But you can't just say that and therefore it's like, well, since there are some limits, this must necessarily be outside those limits. That's a dumb way of thinking. And it pisses me off every time, man. Pisses me off. Parents may not invoke the due process clause to create preferred educational experience for their child in public school. That much is probably true, but is not exactly quite what's happening. It's a way to mischaracterize what's happening, to be quite honest. As per our understanding of the Supreme Court precedent, and the Supreme Court may have some thoughts relating to your understanding, our pluralistic society assigns those curricular and administrative decisions to the expertise of school officials charged with the responsibility of educating children. And the protocol of non-disclosure as to students at school gender expression without the student's consent does not restrict parental rights in the way courts have recognized as a violation of the guarantees of substantive parents. All told, the parents have failed to state a claim. The law protocols applied to their family violate their constitutional rights. We therefore affirm, and we also make the parents pay for this. So the parents have to pay for the cost of the appeal, because their appeal was very, very bad. Very, very bad. And so not only do you lose, you also have to pay us some money. So that's fun. So, yeah, that decision is pretty wild, in my opinion. Well, I don't know if wild is exactly correct, because unfortunately, there are a lot of courts and a lot of people who think this way, and we've seen decisions like this. The fact it's coming from the First Circuit and is now federal law in, the Northeast of the United States, plus Puerto Rico. I'm sure the Puerto Ricans will be thrilled to learn about this as it relates to the transing of the kids. The Puerto Ricans are going to be thrilled. The fact that this is now the law in the Northeast of the United States is a real issue, a real problem. So I think that this case has, a plausible chance of being taken up by the Supreme Court. I don't know necessarily that this is the best vehicle. It's it's not necessarily the cleanest case in some respects, but it's not bad. It's better than many. So if the Supreme Court has appetite for it, there's a reasonable probability they might pick it up. So it'll be interesting to see if the Supreme Court decides to pick this up. You know, it has a pretty legitimate chance of being picked up, I think. Trump's first cabinet meeting is live. We can do a react to that. We'll start another stream. How about that? We'll start another stream and I'll redirect you there. That sounds logical. All right. And I need to actually set up the redirect. Yeah. Whoa, what just happened? Did the live not get created? No, it's there. YouTube has been acting a little weird today. That's why I accidentally created 2 streams, because it's been acting a little weird today. All right, there we go. All right, cool. All right, I'm going to take like 5 minutes to like regroup and get some more water. But we will start the new stream pretty soon, so you won't have to wait very long. So just like 5 minutes for me to stretch and get some water and stuff, and we'll start a new stream, okay? All right, cool. All right, I will see you in just a few moments. I've been on Civil Law. Until very soon, my friends, I hope you're well. Cheers for now, and goodbye.